I think everyone probably on this webinar will have been involved in some shape or another in dealing with preparations for GDPR. There was a huge burst of activity in the run-up, and we'll just briefly remind you of the expectations at the time GDPR came into force. What we'll then look at is what we're seeing on the ground in terms of GDPR, the Information Commissioner's approach, what we're seeing from the Information Commissioner in terms of the decisions and guidance that's coming out. And we'll then have a look at what the courts are doing. There's been a fair amount of activity there. We'll have a look then at the impact on handling incidents. We've been dealing with quite a lot, as all of you might expect, and Nick in particular has been involved in dealing with a fair volume of incidents and first notifications. We'll then have a look at what's going on in the claimant space. We're seeing quite a lot of interesting activity there, and then we'll try and wrap up with some thoughts for risk managers and for insurers alike to think about. In that context, I think what we'll try and do in the course of today is put a couple of polls in as we go through. It'd be interesting to sort of get a feel for what you're seeing, and then as we go through at the end, if there are any questions, we'll try and answer them. What we will do at the end is, if we can't answer all the questions, we'll perhaps circulate a sort of questions and answers sheet so that we'll wrap up any questions there. So without sort of further ado, just a quick snapshot of where we expected to be on GDPR. Part of the reason for GDPR and the Data Protection Act 2018 coming into force was to really catch up with the technology. The previous act, the Data Protection Act 98, was obviously 20 years ago. The world has definitely moved on in that time, so it was about time that the legislators really got to grips and updated the act, particularly, I think, given the enormous developments in how data is captured and used. And so GDPR was very timely in that respect. I think that tied in as well with people's increasing awareness of the fact that big businesses were harvesting data and using it for a variety of purposes. So it was about letting people know what was happening with their data, giving them a chance to have a say in what was done with it, and also giving them options and tools if they didn't like what was being done with it. I think GDPR's had a positive impact and probably achieved many of those aims. In terms of concerns and expectations, the whole direction of travel was really to increase the burden on businesses. The obligations increased. With that, I think from a sort of cynical lawyer's perspective, it was inevitable that the more obligations you've got, the easier it is to breach them. The downside, perhaps, of greater sort of public awareness of data protection issues is that people become more aware of their rights, and when something goes wrong, the remedies. So that perhaps was inevitably going to lead to more claims. That in turn, perhaps a positive thing for the insurance market was that growing awareness and liability was going to perhaps increase the need for insurance. And then we'll touch on in this context as well the fact that the GDPR process requires you to be more accountable in terms of documenting what you do, and has perhaps as well increased the awareness that not only do you have to put your own house in order, but you have risk associated with your supply chains.
Yeah, and just looking in summary to begin with at what the practical consequences have been. As anticipated, there have been a far greater number of incidents and claims, and there was an immediate change in attitude to notification. On the first day when GDPR came into force, we had a law firm which notified their insurers, and they had already notified the ICO on the same day. Now that was really quite extraordinary in contrast to the way people had behaved before GDPR came into force. Conversely, we've heard from the ICO that organisations are struggling to notify within a 72-hour period. I think because we deal with insureds all the time, and because those insureds have bought cyber insurance and been through the process of buying it, I think they and also have the possibility of picking up the phone to an incident response service. I think that has made those businesses that are insured more aware of the need to notify within the 72-hour period.
Yeah, that's certainly an interesting sort of development from our point of view. That when I was talking to Nick before this session, I think our experience is that the process is now quite, so not slick, but it's quite structured, and notifications are going in within the 72-hour period. But it may well be, as Nick says, that we're dealing with organisations who have looked at their GDPR obligations, are aware of the sort of notification, have a product that responds to an incident, and are making good use of that product. But it probably means, as a result, that businesses that are insured are actually responding better. And it's interesting to see from the ICO that people are actually struggling to notify. The other interesting thing is clearly, from what Nick says, some of that notifications happening from the very first day on 25th of May. I think our experience previously was that when we were dealing with a breach, an organisation would say, "Oh, we don't have to notify, do we?" It was very much a sort of please tell us, we don't have to tell anyone about this. Whereas now people seem to have embraced the need to notify, and it's built into the process.
Yeah, I mean the other thing we're noticing from insurance-backed notifications is that where the insured has instructed their own IT service provider to investigate, they're much less thorough than the insurer's incident response team. And I think it's highlighted the fact that a lot of businesses, despite having sought to comply with GDPR and sought to make staff more aware of what's necessary, and having had a greater interaction with their own IT consultants, nevertheless, those IT teams, those insured IT teams, are not nearly as thorough as the insurance-backed incident response teams.
And I think that probably reflects the fact that if you're a business, your IT team will be focused on keeping your systems up and running. Security is obviously part of it, but the IT forensic teams we work with in a post-breach scenario, their primary skill set is finding out what's happened, unraveling breaches. So it's probably a different focus and a different skill set.
It is. I mean, our technical people a lot of them come from military intelligence. I mean, it is a completely different kind of skill set, as Tim says. I think
not the kind of bloke you'll sort of call to fix your machine if you having trouble logging in, but post breach, it's a skill set that you need.
What all of that means is that investigation costs and liability payments are also going up in our experience. I mean, obviously, because there's a much larger number of breaches being notified, and I think the other thing is that cybercrime as a whole is increasing, but the bottom line is that all this is costing insurers a lot more money, I think. Conversely, there was a lot of concern before GDPR about the right to be forgotten, portability rights, lots more subject access requests, and in our experience that doesn't seem to have materialized to the same extent. The benefits of cyber insurance are, I think, becoming rapidly more apparent as people have become more conscious of their data protection obligations and are being hit and having to notify. And conversely, the gaps in their existing insurance portfolio, if they haven't got cyber insurance, and also gaps in cyber cover, are also becoming stress tested and more apparent.
Now, in the context, I think there are two things, aren't there? One is it's brought home that traditional policies don't necessarily cover these incidents, and the other thing is I think what we're seeing and what the market's seeing is sort of the products become refined and tailored, so that organisations are beginning to think about how to get a cyber policy that really fits their business rather than just a sort of a one hat fits all. And that's certainly been the pattern we've seen in the market, is of tailored products for sort of particular sectors.
Yeah, that's true. But I think there's also an expectation by a significant number of policyholders that if they bought a cyber policy, it's going to cover absolutely everything. And of course it won't, and it won't cover every sort of incident. And I mean, one particular issue that has cropped up is a situation in which there's an insured hasn't been negligent, isn't criticisable, but nevertheless money's been lost, and that's an issue in terms of compensation under a lot of cyber policies. Just briefly touching on the point Tim made, big headline fines. We're going to look a bit more at about that later, but so far the ICO doesn't seem to be fining ordinary businesses to any great extent that we've noticed it. And the other thing, I think that the big sea change for businesses and insureds is the much greater consciousness of what accountability means in practice. If you're having to make detailed notes of everything you do following an incident, you quickly become aware that the accountability principle is quite a cumbersome thing to deal with.
Now, the ICO, as again, sort of following up on what Nick said, they're under an awful lot of pressure at the moment. They were expecting to be busier. They're an awful lot busier. We've sort of flagged some of the stats at the top there. So more than 8,000 breaches reported since GDPR came into effect. I think that's a big step up from where we were. That increase in complaints from the public, again, more than doubled. So the volumes coming into the ICO are enormous. The indication was as well they're getting something like 500 calls a week on their notification hotline. One of the challenges actually seems to be that people are taking too cautious an approach. The ICO, the senior ICO management team have sort of been out on the road quite a bit. We went to one of their seminars earlier in last year, where the General Counsel was speaking. It was a seminar hosted by one of the specialist or barristers' chambers. An interesting thing that came out of that was all the advice from the barristers was notify everything. That would seem to be on the basis that there's no punishment for notifying that something that doesn't need to be notified, but there is a punishment for not notifying something that does need to be notified. So that was a very consistent theme, and yet when the General Counsel from the ICO came to speak, they said, please stop notifying things that don't need to be notified. So there's a bit of equilibrium to be obtained. It may just be that we're in the early stages here. In the context of the helpline, for example, the ICO said that of the 500 or so calls they're getting a week, about a third actually get to a point where both parties agree it wasn't necessary to notify. So there's a bit of work to be done around that. That perhaps ties in then to the fact that whilst there are still decisions coming out of the ICO, a lot of them relate to events before the GDPR and before the Data Protection Act 2018 came into force. So some of the fines that are coming out, for example, with Facebook, with Yahoo, are under the old regime. So we're not seeing the kind of headline grabbing fines under GDPR that we were expecting to. That doesn't mean we're not going to, as I've noted at the bottom of the slide. We've got some big cases in the pipeline. That's BA, the Marriotts, the Eurostars, the Cathay Pacifics, TSB, Dixons, a host of big names, big breaches. So we'll see where we get to on those. The one that's perhaps grabbed the headlines in the intervening period was the French were quick out the blocks to fine Google for 50 million euros. We'll see when that gets to. Google, I think, have said this week that they're going to be appealing that, and we'll see where we end up. One of the interesting things Nick was mentioning in the context of breach reporting, certainly in that sort of 72-hour period, is that the ICO, it seems to be shutting down cases relatively early.
Yeah, I mean, what we're finding is that when we've got an incident, we do the preliminary investigation very quickly within the 72-hour period, fill in, there's an online form, for those who don't know, there's an online form that the ICO has on its website that you complete with basic details of the incident, what you've done about it, who's likely to be affected, what type of data may have been affected, all that sort of thing. We usually tell insureds at the moment that they needn't be overly concerned, because what's tending to happen is we're submitting the preliminary report and the ICO in many cases comes back a few weeks later and says that the case is closed. Now that may be partly because they've got such a backlog, maybe partly because there's a bit of a grace period, but it is interesting that so far the ICO is not taking a forensic approach to incidents following the submission of the preliminary report.
Is that likely to be as well, I guess, a reflection of the fact that if as a business you've got a response team and you've got a cyber policy and that team's been triggered, the ICO will take some comfort from the fact that actually a team's gone in, there are lawyers on it, the business is obviously engaged, it's being investigated on the IT side, and it may be that even within that 72-hour period, some assurance can be provided to the ICO as to who's affected and what's being done to mitigate the impact, or if there is any impact. It might be that after 72 hours you can look the ICO in the eye and say, well, actually, there is no substantive impact on individuals.
Yeah, I think that's absolutely right, and I think the fact of having a well-coordinated multidisciplinary team with really expert technical people who can get to grips with exactly what's happened and report on it very quickly, I think that does help. It demonstrates to the ICO that the whole thing's under control, and it's also possible in most cases to get a good idea of whether a significant number of third-party data subjects are likely to have had their data compromised, and whether or not there's been any or likely to be any significant impact on them. So all of those things, as Tim says, I think the fact that of getting to grips with it quickly and professionally and reporting reasonably comprehensively within the 72-hour period, I think that does help.
And I think as well that it's always, when you're in the maelstrom, it's very easy to think that the ICO is going to immediately sort of bring out a stick and clobber you for a breach. In fact, the general tone seems to be it is about carrot rather than stick, and that ability to evidence that you're engaging with a breach, you're taking it seriously, you're responding, and you're responding in that multidisciplinary coordinated way, will provide enormous reassurance to the ICO. When the ICO have got other fish to fry, the ICO dealing with serious sort of bad sort of criminal breaches, so they've got some big incidents to deal with, they've got big sort of regulatory issues to deal with the sort of big tech companies, and so if you're on their radar, but in the context of dealing with an incident, that may mean that they're not going to be that interested in delving deeper when they've got some really big issues on their plates. Now, in terms of guidance, I think we both had a look to see where we are. I think it's fair to say what we've seen is that the ICO is so busy, they haven't really refreshed all their guidance on DPA. Would that be a fair?
Yeah, I mean, basically, if you look at the ICO website, there's a list of all the guidance under the old DPA, and a note basically saying, as far as the ICO is concerned, a lot of it is still valid post GDPR. There have been a number of new guidance notes on consent, legitimate interests, but I think it's a work in progress for
yeah, they've got a lot on. We haven't rehearsed the guidance here. The ICO guidance tends to be very straightforward. It's easily digestible, and there's sort of not any great purpose, I think, for today's purposes in rehearsing it. But it's always worth keeping an eye on what they're doing and touching base with their website every now and then, just to see if there's anything new there. Now we've sort of touched on the ICO and the broader sort of original remit of GDPR. What's going on the ground, Nick, in terms of what you're seeing?
Well, as I said, there's a sea change in Insured's approach to notification. They're doing it very quickly. GDPR publicity before May 2018 definitely seems to have had an impact in terms of businesses getting to grips with the GDPR principles and seeking to apply them. Most businesses that notify can tick the box on the preliminary form saying they've had GDPR training, and compared to a few years ago when most people didn't understand anything about cyber risk or data protection, really, it's a completely different environment. There's because I think of the much greater number of notifications, we've noticed a much broader range of businesses notifying. I mean, it's not just professional firms. There's event companies. There's engineering firms. Quite a lot of schools are getting hacked. There's a wide variety of
yeah, no, we've got everything from the major airline incidents, the big financial institutions,
vets,
to vets, to car dealerships.
Yeah,
it's a real range, and in that context, we'll touch on it in a moment. One of the things that's interesting as well is the fact that these incidents are landing on our desks. That individuals affected by a major breach or a modest breach are looking to instruct solicitors to take it to a different level in a way perhaps they weren't before GDPR. It may be that's a consequence of all that publicity or that highlighting of the regime change.
Yeah, I think that's right. I mean, one particular type of incident, ransomware incidents. Obviously, there are more of them. They're becoming more common. They're becoming lower level in terms of what the demands are. But those incidents are being notified to the ICO as well. Whereas I think many of the businesses who are now notifying them to the ICO would have thought twice about doing so. Faced with a fine, paying 5 or 10 grand, they'd probably just rather have gotten rid of it. But actually, under the GDPR, you are obliged to notify because the fact that you are unable to access personal data is a data breach. It falls within the definition of data breach.
And against that backdrop, we've got a couple of polls that we'll run briefly. We won't interrupt for too long. We'll put them up for a few seconds each, but it'd be very interesting to get a feel from today's audience as to what you're seeing and what's causing incidents. I think whether the number of claims is going up, what's triggering incidents. It's always very interesting to see what's going on. One of the downsides historically, and we haven't got the ICO sort of that full annual review for the year, obviously, because we're not a year into GDPR. But historically, it's been quite hard getting accurate data because that sort of initial first reaction was, I don't want to tell anyone really if I can't help it. There wasn't an awful lot of data about the number of incidents and what was causing them. So it'd be very interesting to see what's going on there. I think the polls are on the screen. And we'll take stock of the answers if we can at the end, and if not, we'll include them in our note when we follow up after this session. What we're going to look at after this is the decisions from the courts. Now, as I said, even the ICO, who might be expected to be a bit more sort of on the front foot, is still sort of getting through the backlog of pre-GDPR incidents and complaints. So it's no surprise perhaps that the courts are in a reasonably similar position. As you'll appreciate, that if there's been a breach since May, there's every prospect that a claimant will want to send a letter of claim, follow a pre-action process before issuing proceedings, and then those proceedings would have to get to a conclusion before we get to a stage where the courts are making rulings on the Data Protection Act 2018 and or the GDPR. But what we've tried to pull out is some of the cases that are of interest or will have an impact irrespective of whether they're under the 98 Act or the 2018 Act. I'm not going to dwell enormously on Morrison's. I think it's got a lot of publicity. We issued a very detailed note, and if you haven't received that note, we'd be delighted to share it. Effectively, the two key things that came out of the Morrison's case, we're dealing here with a disgruntled employee who steals a vast amount of employee data relating to 100,000 Morrison's employees and dumps it on the internet. The first thing that was interesting was that for once we've got a defendant able to successfully defend primary liability because Morrison's had very, very good systems and policies and procedures which held up. The downside was that irrespective of that, they were found to be vicariously liable for the actions of the employee concerned. I think within the tech media sphere, that's been regarded as really harsh and an unfair outcome. I think from talking to colleagues who deal with casualty matters, it's no surprise at all. It's utterly consistent with the train of case law or the direction of travel on vicarious liability. The bottom line seems to be that if you could be held vicariously liable for an employee who punches someone or abuses someone, then being vicariously liable for an employee who takes a bit of data and does stuff with it they shouldn't is not an enormous extension, if it's an extension at all. It's just a nasty surprise, perhaps, for people working in a tech media space. But it's utterly consistent with the previous case law. So it's going to be hard, I think, to persuade the courts to take a different line there. But it does mean that there comes a point where no matter how good your policies and procedures are, deliberate actions by employees could cause businesses problems. And that in Morrison's, the other, I guess the interesting thing there was that the judge said, well, appreciate this is tough. There's a public policy driver for this, which is that we've got a group of individuals who have been wronged. They haven't done anything wrong themselves, and we're going to compensate them. It may be harsh, but so be it. If you think the economic consequences are going to be significant for you, get an insurance policy. That was pretty much exactly what the judge said. So it's very clear that the court's going to treat insurance as the way to deal with vicarious liability in these situations. Lloyd's and Google is primarily interesting, I think, because it shows how inventive the claimant side of the profession, the legal profession, is getting. I think Lloyd's was represented by Mish Kondiraya. He was the former employee of Which, the consumer organisation. What he was trying to do, we've got an interesting distinction in the UK between class actions, group actions, I guess, as we know them here, where you start with nobody and people have to sign up, and representative actions where everyone's in from the outset and you have to opt out. So that opt-in, opt-out bit is very important. In the US, my understanding is class actions opt out, so you start with everybody in. But it makes an enormous difference. So, for example, if you've got opt out in Morrison's, you start with 100,000 claimants, whereas in fact only 5,000 signed up as in an opt-in process. And for example, on BA, where you might have, say, up to 400,000 claimants, whether you start with 0 or 400,000 makes a very significant difference to where you might end up. So the attractions of a representative action where you start with everybody were quite significant. The challenge for the claimants was that in a representative action you have to have the same interest, and the notable point here was that the court said, well, hold on, that's not necessarily the case here. Lloyd's really spun out of the Vidal Hall and Google case, which attracted a lot of publicity. Vidal Hall and Google, about 6 or 7 people brought a claim saying that the Safari browser had been harvesting their data when it shouldn't, and that was being used to send targeted adverts to their devices. Now it could be a mobile device, a tablet, or a laptop. And where you shared a device, that meant that the person who you shared it with could see what was the product of the targeted advertising. And if, for example, you'd been diagnosed with a medical condition and were investigating it, but you might not have told anyone else, there was a prospect that that information could be revealed at a sort of lower level. For example, if someone was planning a surprise honeymoon or trip and got targeted advertising from travel companies about where they were going, that could give the game away. So there's a whole host of sort of different possible reactions. Now in Vietnam, we still don't know what the sort of nature of the information concerned was, but in Lloyd, what the court said was, well, hold on, there is this range, and not only is it that range, but there's a whole host of people who might not give two hoots about whether they're hit with targeted advertising. And then might be some people, if, for example, I know you're looking for a new kitchen or a holiday, if you suddenly got advertising for it that produced a really good deal, you might be quite happy to receive it. And against a backdrop where you've got that whole spread of potential reactions, you couldn't say that everyone had the same interest. And so the court didn't let the representative action go ahead. So that's quite good news. The Cliff case, I've flagged really because it's useful, interesting on quantum. What we're seeing is claimant lawyers seize on any big award in a privacy case, and I'll touch on that, or Nick and I will look at this a bit later. But because damages in privacy and breach of confidence, data protection have broadly been aligned all the way through, any big award catches the attention of claimants. So the phone hacking cases where we were seeing awards of £70,000, £260,000, Cliff with £210,000, but with special damages to come. Obviously, pound signs are being seen by claimant lawyers. So it's worth being alert to that. Now, we think these are very different. These are publications in sort of mass media, in national newspapers and on the BBC. It's a whole world away from your classic data breach. But at the same time, it's impacting on where claimant lawyers think cases are going to end up and in the expectations of claimants. We've touched on subject access requests. I think interestingly, we're seeing only a sort of small increase in the number of requests. What we're seeing though is an increasing awareness that subject access requests can be hugely complex. It might be straightforward if you're a sort of credit monitoring company. It's a whole new world where you're dealing with information about third parties, particularly if you're dealing with, say, anything to do with crime or safeguarding or anything like that. What we're also seeing is that subject access requests are particularly popular with your more challenging claimant. So you might have someone who's already made a complaint to you. You might have someone who's made a complaint about the complaint. That's not unusual either. If they make a subject access request, there might be a whole host of material that's generated by other processes. So if there's been an investigation, if people have been spoken to, provided evidence, if an independent investigator or expert's been brought in, there could be a whole load of material that might be very sensitive. And you can understand in those situations that you can effectively buy off the concerns of your requesting party by giving them the information they want. But if you've just handed over the witness statements that you've got from your investigation or the whistleblower's information or the experts' views, you might generate a whole load of new complaints from people who really don't want that information to go to your requesting party, particularly if they're a sort of serial complainant or a challenging complainant. So what we are seeing is a lot more situations where there is mixed data, and we're more often than not being asked to help with the process of identifying what should be disclosed and what shouldn't be disclosed. And that can be quite a complex process. One of the judges in one of the cases said, there seemed to be an expectation that under the old regime, you just put someone's name into a computer, hit print once you've searched the system and handed it all over. That's not the case because of the challenges around mixed data. And that was one of the things that came out in the B case. Sorry, that's a long explanation as to why B's there. B was a mixed data case. a patient had made a complaint. The doctor had gone through the GMC process, so the GMC had investigated it, got an independent medic to examine the situation. There had been criticisms, but not perhaps at the stage or at the level of seriousness that would have supported a negligence claim, but nonetheless criticisms, and the doctor didn't want those going in the hands of the complaining patient. The patient was given a summary of the medical report, but not the whole thing, and wanted the whole thing and made a subject access request. The doctor resisted that for understandable reasons. He didn't want to, I guess, air his dirty laundry to the complainant. It was also reasonably apparent that the complainant wanted, or one of the primary reasons was to bring a claim against the doctor. The GMC decided that it, in order to support its sort of transparency and needed to give the full report to the complainant. I also felt, I think, that he had a lot of information, and because he was the complainant, he knew which doctor it was, he knew all the ins and outs of it, so it wasn't that the case where he was going to be given anything that would dramatically change what he already knew. The downside for sort of parties receiving subject access requests was that in the earlier case law, the courts had indicated that there was a presumption that that it is not reasonable to disclose it unless you've got the consent of the third party. In B, the court said that was wrong, which isn't helpful because that makes the process of deciding whether to disclose a bit more nuanced. So again, not necessarily particularly helpful. It is, I guess, helpful to the extent that every time a court looks at this, we get a bit more of a steer as to how these things will be dealt with. The upside, if there is one, and I think there is that what the court said was you have a lot of discretion as the party receiving a request as to how do you deal with it. The court isn't going to just brush aside what the data controller has done and start afresh. The court will look at whether the process was followed, and the decision of the data controller in deciding whether or not to disclose material is going to be harder to challenge as a result, I think. So the comfort, if any, from B will be that the courts are more likely to uphold decisions as to what should be disclosed or not. Lonsdale's, I'll mention very briefly, simply because it shows the tangle you can get into sometimes. Mr. Lonsdale was a barrister who had a couple of sort of property businesses, one with other people and through some companies. As ever, if you're dealing with a legally qualified complainant, they're trickier to deal with. The bank froze his account because there'd been a suspicious activity report, and in this context it's always difficult when you're dealing with two sets of SARs, but there was a suspicious activity report which meant they froze the accounts. Mr. Lonsdale wanted to find out what was behind that and made a subject access request. The bank effectively, sort of in essence, point blank refused to provide the material. The bank said he wasn't entitled to it and applied for summary judgment on his claim, which I think Mr. Lonsdale did likewise. The court said, well, the bank's approach was flawed, that the material, given the case law to date, it wasn't just a case that once the bank started investigating, this was all the bank's business. If it was investigating Mr. Lonsdale and his activities, it was going to be his personal data. That meant the full process had to be gone through. There was also an issue as to what extent the crime exemptions applied, and some of that was going to be, it would need to be determined on the basis of more information, potentially even at trial. But it wasn't a case where you could simply dismiss out of hand someone's subject access request, and it's used for a reminder of the broad approach that the courts have taken toward his personal data. The last two cases come out of the European Court of Justice. The first is one that related to a fan page on Facebook, where the court effectively said that not only Facebook were the data controller, but also the fan page. And the second was a case where a Latvian chap who was being, I think, interviewed by the police or turned up at the police station to answer some questions, filmed what was going on, but he was in a public area where any member of the public could see what was going on. He filmed it, put it on YouTube, and in many instances, if you're processing for your own purposes, you'll be exempt from data protection legislation. But here the court said, well, actually, by putting it on YouTube, you've stepped away from being from that exemption of just doing it for your domestic purposes, and you're now a data controller. It may be that some of the journalistic exemptions would apply, but those questions were referred back to the Latvian courts. But in both cases, it's a reminder that quite broad approaches are being taken to who is a data controller and what constitutes processing. So some lessons to be learned there. I think that very broadly, and Nick would chip in if he disagrees, I guess, the direction of travel seems to be to broaden the application of the GDPR, the Data Protection Act. The case law which we had found historically most useful in defending claims or narrowing the ambit is being challenged and occasionally overturned or overruled, which is unhelpful. So the direction of travel, I think, from the courts is to increase the application of data protection legislation.
Yeah, I think that's absolutely right. I think it's a reflection of greater public consciousness of the value of personal data and conversely the damage it can do. That's being reflected in the change in the court's approach, and judges are becoming more familiar with data protection issues and also recognizing that greater public consciousness of the value and potential damage that personal data can do. So I think the court's approach is a reflection of changing public attitude.
And that leads us into this sort of next slide in terms of how these sort of developments are impacting on the front line. What's your impression there, Nick?
Yeah, I mean, basically, the incidents we're seeing and dealing with are tending to follow a fairly regular pattern. That's partly due to the reporting requirements, the ICO reporting requirements, but there are a number of interesting features which I will describe. Firstly, in terms of what one needs to do in response to these incidents, there's not much of a choice in terms of what you have to do and what it's going to cost. You need the technical team and a lawyer on the first call, and the technical team has got to be expert, and they've got to find out what's happened quickly and deal with it to stop the whole thing getting out of control, because as has been said on numerous occasions, cyber incidents can blow up very quickly. So it's partly the need to notify within 72 hours, and partly the fact that everybody's conscious, including the business that's been affected, that they've got to deal with this quickly. So following the initial call, there's a technical investigation. My role, Tim's role in terms of the legal input at that stage is normally confined to sort of commenting on what's got to go into the ICO report and telling the insured where they stand in terms of what's likely to happen as a result of their compliance or non-compliance with GDPR obligations. Attempting to identify the perpetrator, I mean, it's fairly common knowledge amongst everybody now that you're unlikely to get hold of whoever it was in Kazakhstan who's responsible. Occasionally, very occasionally, it'll be someone in East Grinstead, but that's the exception that proves the rule. The other thing that everybody wants to do as quickly as possible is clean the system and get it up and running again if it's not running, and that again involves a quick expert investigation of what systems have been affected, and how data can be restored, whether it can be restored. And in my experience, as I was saying earlier, the insureds or businesses' own IT teams are very much slower and less adept than people who've been doing it umpteen times a day now for for a couple of years. The big burden which surprises insureds is the need to identify individual data subjects who've been affected. And I mean, there's a dual notification obligation, notifying the ICO and notifying affected data subjects. And that is, whether it's a ransomware attack or a phishing attack or whatever, the systems that have been compromised need to be examined. The email accounts that have been compromised need to be examined. You need to find out who the individual data subjects are, and then you need to weigh up in each individual case whether they need to be notified or not. And that is time consuming and expensive. And it's also, from the businesses or insured's perspective, it's often the most frightening bit, because it means they may have to notify a whole load of their clients that their personal data has been compromised. So that's an issue. And what we try to do is to apply the working party, the Article 29 working party guidelines on this as effectively and efficiently as possible, and narrow down the number of individual data subjects that need to be notified. But you still need to keep a record pursuant to the accountability principle under GDPR. You need to keep a record of everything you've done. So at the end of the day, the business or insured may not have to notify that many people, but it does need to have a careful record, which we usually put in the schedule, of whose data's been compromised and the reasons why it's necessary or unnecessary to notify them. The other common features are that phishing attacks are probably the most common form of incident we're seeing, and that says a lot about businesses still failing to adequately educate their staff, particularly senior staff, about phishing and what to look for when you get a slightly odd email. And it's worth bearing in mind that phishing attacks are often they're a precursor of the theft of very large sums of money. So and when that money's been stolen, the other feature is that in the businesses, that particularly insureds, that have been hacked, are anxious to for money to be paid out quickly, particularly in relation to conveyancing transactions, because otherwise the conveyancing transaction is going to fall apart. So there's pressure on insurers to say, okay, let's get it paid out, in circumstances in which, in some cases, it's not completely clear that the insured is at fault. There's as we've been saying, there's a huge increase in number of incidents, and therefore the amount of compensation. And I think going forward, insurers are going to face challenges in terms of deciding in a rather less sympathetic way whether they're going to pay out or not. And those decisions are often going to have to be made fairly rapidly.
Yeah, and again, it's an evolving market, so getting the pricing right and seeing how the claims play out, particularly in this first GDPR year, is going to be a learning process, I guess, in any event. One of the things we thought it would be useful for today's purpose was to sort of give an insight or some insights into what we're seeing on the front line. I think that the team as a whole has seen interesting activity in the claimant lawyer space. In some ways, it's perhaps no surprise that claimant law firms, particularly in the casualty field, are under enormous pressure with portals and fixed fees being applied, with CFAs and success fees being stripped out, and all of that sort of increasingly, I guess, commoditizes their product, but it's put pressure on their margins. They've got lawyers with sort of claimant skill sets sort of twiddling their thumbs looking for things to do, and it can come as no surprise, I guess, that they've looked at data and data breach as something that they can get involved in. And it was notable, I think it was around the BA breach, but it might have been one of the others where on TV you're starting to see the sort of Lee Days and Erwin Mitchells putting forward people who are ostensibly data experts. And we know these guys are highly unlikely to be advising businesses on compliance. These are claimant litigators who have got an expertise in pursuing claims, and there's every prospect that they're going to use those sort of big class action skills they've got and the legal expertise they've got to pursue claims in this space. We've even seen some of the smaller injury firms start to crop up more and more often. There's particularly a couple of firms in the Northwest we're seeing on a regular basis, and this does seem to have a knock-on effect. They are pursuing some of these smaller claims, and it may be that they are just simply good at identifying claimants. They're good at marketing their expertise. So if you Google them, they're turning up quite high up on a Google search, and maybe they're good at sort of claims farming. It's a skill set claimant casualty lawyers have got. What I think we would say is they don't necessarily have the specialist expertise that we might see on the defendant side. A lot of these people are making a sort of transition from injury work to data breach. So they're often trying a bit of a scattergun approach. The interesting thing there is that whilst it's not one cap fits all, you can, as a claimant who's had information go astray, look at breach of confidence, misuse of private information, and breach of the Human Rights Act, your sort of right to respect for private life, as well as data protection. And we're often seeing all four causes of action being sort of thrown at us with a slight expectation on the part of the claimants that we'll work it out on our end, because they don't always necessarily get it absolutely right, but they've done enough to get it off the ground. The other notable thing is that there's an exception in claims of defamation and privacy that success fees, CFAs and success fees can still be pursued. Relentlessly in this area, we see 100% success fees be claimed, because what claimant lawyers are saying is these are really complicated specialist technical areas of law. That has a number of consequences. One is that it increases their chances of getting a high success fee. It increases their chances of arguing for a high hourly rate. We're seeing some fairly mind-boggling rates. We've settled one case relatively recently against one of these firms where the payment for a reasonably significant breach in terms of the nature of the information for 4 claimants, adults and children, where there was a suggestion they might need to relocate as a result of the information that was disclosed. We said the claim was for over £100,000. We settled it for 15. We've got a bill for nearly 120. Hourly rates at £400 an hour, uplifts. One of the other challenges in that space.
Claimant costs.
Yes, absolutely. One of the other things we're seeing as well in that context is that claimant lawyers want to get these out of small claims fast track. They want to get them in multi-track. To generate costs, it's easier to argue that you should get all your costs, and it's easier to argue for higher rates. And they're often succeeding. I think in practice, courts aren't dealing with volumes of these cases, and the challenge is going to be persuading judges across the country that these can be dealt with in a more straightforward manner. If you're speaking to a judge who doesn't deal with many of these cases, and these are areas of law they're unfamiliar with, it's an easy sell for the claimant to say to them, well, this is terribly complicated to go into multi-track. So that's one challenge, and it may be that we'd like to see what we've seen in intellectual property with a specific dedicated court come into play at some stage, where, say in London in the IP court, you've got a fixed limit on costs. It's a streamlined process, and something like that might be quite handy.
And you've also got a small claims branch of the IP courts in IPEC, and so yeah, I agree with Tim. I think that needs to happen, because at the moment you're getting ridiculously small incidents blown up with.
So there's a lobbying piece to be done around that. I think the other thing we've seen, bizarrely, what we didn't see really in the first 20 years, well, 18-20 years when we've dealt with substantive DPA legislation, lots of claims for injury. So from 2000 to 2018, hardly any, and certainly none successful. What we're seeing increasingly is claims for psychiatric injury caused by the breach. So this is not just distress. This is people saying they've suffered a tangible psychiatric injury. It may well be that this is because the claimant lawyers we're dealing with are injury specialists, and this is a comfort zone for them. They know what they're doing in this space. They also seem to be terribly good at identifying experts who will back them up. And it may be that we're entering the realm of these sort of soft tissue, travel sickness type claims, where the experts are a little bit lazy, if that's the right word, because they don't think any are going to come to trial because the quantum isn't always very, very high. They're prepared to put their names to reports which perhaps if they said, oh gosh, you know, if this goes to trial and I'm cross-examined, will this stand up, may not be sustainable, because we're seeing quite small breaches with relatively anodyne information is said to lead to psychiatric injury. But that's definitely a pattern we're seeing and something to look out for. And again, it might be a question of picking the right case to have a dust up over, in the same way that we obviously going to have those dust ups with the claimants on costs. I'm conscious we're probably coming to the time to wrap up. I think what we're seeing is that the coming into force of GDPR has definitely raised awareness among the wider public. That's leading to a probably more feisty approach to breaches. People are willing to take up the cudgels if there's been a breach, and we're seeing, you know, people go to solicitors over relatively modest breaches in a way we didn't see before. We're seeing vulnerabilities on phishing. So a lot of there's still classic sort of human error here. It doesn't really matter to some extent how good your systems are. You can have systems that sandbox, that sort of park suspicious emails and try and filter out as many as you can. But to some extent, as a business, you will still be in the hands of individuals not to click on that attachment or click on that link or not to enter their details. And that's still perhaps happening more than anyone would like. Supply chain's got to be looked at as well. And we're seeing, the claimant legal community pile in. We're seeing the courts be a little unsympathetic, so the defendants aren't coming away with the kinds of outcomes that perhaps we'd like. So it's a challenging environment, and may well continue to be for the foreseeable future. Nick?
Yeah, I think as far as mitigating risk is concerned, there are some easy wins, both for insurers and businesses. I think the phishing, as we've been saying, seems to be cropping up an awful lot. Phishing attacks leading to the loss of hundreds of thousands of pounds because someone clicks on an email. And I think if insurers can emphasize to their insureds, and businesses can emphasize within their organizations that this is an issue. And I mean, we get regular phishing tests, so from our IT team, I think that's a good thing to do. I think information security generally is still a bit lax, and I think there's also there are still too many businesses who don't recognize the difference between cyber incident response experts and their own IT team. And it might be a good idea for those businesses that can afford it to get some input from cyber incident response experts before they have an incident.
Having a plan is definitely a good idea. If that's the only takeaway from today, and I hope it's not, it would be a very useful one, I think. Thank you very much indeed for joining us today. We'll try and answer any questions that have come through, and we'll send our slides out in the usual way. But I hope that's been useful, and thank you very much for joining us.
Thank you.